Very good evening to all my fellow citizens and people around the world. Um, Today, I'm going to be speaking on legal practitioners, and as well as the patriarchy and power relations which exist in the court systems. So we really need to understand that aspect of feminist study. And feminist legal theory is a way to understand how the legal system subordinates women and to propose remedies. So it views laws as a site of political struggle and a product of social construction of reality. Feminist legal theory exposes how legal institutions, doctrines, and culture perpetuate gender hierarchy. So, the court system itself is very much, um it is very much patriarchal in nature, and very few women, for example, are a part of the court system, and the ones who are absorbed within the system in such a way that they are performing the patriarchal structure itself. So feminist legal theorists criticize traditional view of law and legal reasoning and patriarchal assumptions that are reflected in laws. Feminists evaluate legal institutions such as courts and law firms in terms of how they affect women's lives and interests. So, what we need to do is challenge the power structure. And many feminists, for example, claim that the conception of power as power over is a product of patriarchal um, domination. So, um, they believe that our conceptions of power are shaped by uh, power relations. Feminist legal theorists use hedonistic jurisprudence to show that law treats women as less humans and give them fewer rights than men. And this is, even in the present century, this is a fact. Issues like marital rape, etc., are not recognized even in India. Even the center just few days back refused to grant marital rape as a crime, as if it's going to destroy the marriage system. After all, feminist women, etc., the ones who are concerned about women issues, are also concerned about the fact that safety of women within the household is a compulsion, especially in patriarchal societies like India and many of the other countries. Obviously all the countries are, but like some countries are more than others. And that's the whole thing. And uh, what I wanted to put forward was the whole thing that feminist legal theory was directly created to recognize and combat the legal system built primarily by the and for male intentions, often forgetting important components and experiences women and marginalized communities face. The law perpetuates a male valued system at the expense of female values. Secondly, feminist legal theories is dedicated to changing women's status through a net rework of law and its approach to gender. It is a critique of, for example, American law that was created to change the way women were treated and how judges had applied the law in order to keep women in the same position they had been for years. The women who worked in this area viewed law as holding women in far lower place in society than men based on gender assumptions, and judges have therefore relied on these assumptions to make their decisions. The movement originated in 1960s and 70s with purpose of achieving equality for women by challenging laws that made distinction on the basis of sex. So, one example of sex based discrimination during these times was the struggle for equal admission and access to the desired education. The women's experiences and persistence to fight for equal access led to low rates of retention and mental health issues, including anxiety disorders. through this experiences, they were influenced to create new legal theory that fought for their rights, and those that came after them in education and broader marginalized communities, which led to creation of legal scholarship, feminist legal theory in the 70s and the 80s. It was crucial to allow women to become their own people, they're through becoming financially independent and having the ability to find real jobs that were not available to them before this. The foundation of feminist legal theory reflects these second and third wave feminist struggles. However, feminist legal theories today extend their work beyond overt discrimination by employing a variety of approaches to understand and address how the law contribute to gender inequality. The first known use of the term feminist jurisprudence was in the last 1970s by Anne Scales during the planning process for Celebration 25, a party and conference held in 1978 to celebrate the 25th anniversary of the first graduating women from Harvard Law School. And so this is the whole thing, and there were many schools which spoke about feminist jurisprudence, such as the liberal equality model, the sexual differences model, the dominance model, the anti-essentialist model, and the postmodern model. Now, as far as the feminist equality model was concerned, the liberal equality model operates from within the liberal legal paradigm and generally embraces liberal values and rights based approach to the law, though it takes issues with how the liberal framework has operated in the practice. This model focuses on ensuring that women are afforded genuine equality, including race, sexual orientation, and gender, as opposed to nominal equality often given to them in the traditional liberal framework, and seeks to achieve this either by a way of more through application of liberal values to women's experience, to the division of liberal categories to that of gender. The liberal equality model applies Kimberly Crenshaw's theoretical framework of intersectionality in relation to persons lived experience. For example, when a black women are only provided legal relief when the case is against her race or gender, so not the intersectionality of the black women, which has to be considered. Then another is the sexual difference model. The difference model emphasizes the significance of gender discrimination and holds that this discrimination should not be obscured by the law, but should be taken into account by it. Only by taking into account differences can the law provide adequate remedies for women's situation, which is in fact distinct from men's. The difference model suggests that differences between women and men put one sex at a disadvantage. Therefore, the law should compensate women and men for their differences and disadvantages. These differences between women and men may be biological or culturally constructed. And that's the major point which most feminists agree upon. And the difference model is in direct opposition to the sameness account, which holds that women's sameness with men should be replaced. To the sameness feminists, employing women's differences is an attempt to garner greater rights ineffectual to the end and places emphasis on the very characteristics of women that have historically precluded from uh, achieving equality with men. Then the dominance model. The dominance model rejects liberal feminism and views the legal system as a mechanism for perpetuation of male dominance. By recognizing the foundation of law, scholars are able to conceptualize how women and marginalized communities were not written with the foundation of many structures limiting access and equal rights in all the areas of life. Further, dominance theorists reject the difference model because it uses men as the benchmark of equality. While the liberal equality model and difference model aims to achieve equality for women and men, the dominance model ends goals is to liberate women from men. Dominance theorists understand gender equality as a result of an imbalance of power between women and men, and believe the law contributes to this subordination of women. It thus joins certain strands of critical legal theory, which also consider the potential for law to act as instrument of domination. In account of dominance proposed by Catherine McKinnon, sexuality is central to dominance. McKinnon argues that women's sexuality is socially constructed by male dominance, and sexual dominance of women by men is a primary source of general social subordination of women. According to McKinnon, the legal system perpetuates inequality between women and men by creating laws about uh, women's using a male perspective. Then let's look at the anti-essentialist model. Anti-essentialist female legal theory were created by women of color and lesbians in the 80s, and who felt that feminist legal theory was excluding the perspective and experiences of these women. Anti-essentialist and intersectionalist uh, critiques of feminists have objected to the idea that there can be any universal women's voice, and have criticized women feminists such as black feminists for implicitly basing their work on the experiences of white middle class heterosexual women. The anti-essentialist and intersectionalist project have been to explore the ways in which race, class, sexual orientation, and other axes of subordination interplay with gender, to uncover the implicit detrimental assumptions that have often been employed in feminist theories. And let's look at the modern model. Postmodern feminist legal theorists reject the liberal equality idea that women the like are like men, as well as difference theory that women are inherently different from men. This is because they do not believe in singular truth, and instead see truth as multiple and based on experiences and perspectives. Feminists from postmodern camp use a method called deconstruction, in which they look at to find hidden biases within them. So yeah, these are some of them, and over half of the cases involving feminist issues in Supreme Court of UK include elements of feminist jurisprudence in their judgments. The most common of feminist legal reasoning was placing the case within a wider scope of experiences of those involved, or another wider context within which they could involve empathy for women in different cases. Judges also considered the impact of judgments on divergent groups, challenging gendered bias, and commented on historic injustice. Some feminists, in fact, entered the court reasoning as common uh, knowledge, with feminist scholars being referred to. Lady Hale had used intersectional arguments, arguing that the extent of the concept of violence in the case of domestic violence outside of feminist violence. And I mean, if we look at the this was by Rosemary Hunter, feminist jurisprudence in UK Supreme Court by many feminists. So we need more of that in India and South Asia, and this particular aspect would be extremely interesting when women feminist women enter the courts and bring about changes in the structure of looking at women, crime against women, and the best possible solution to gender issue is resolved, because it's still an unresolved issue of the world. And as Helena Sixu would say, it is one of the most unresolved issues, the issues of the world. And what in the present century, the conflict we face right now is that of uh, difference between men and women. So this is the major issue which we need to understand of today. And for today, thank you so much. Thank you.